Malcolm Burrows, principal of Dundas Lawyers. Dundas Lawyers is a boutique, award-winning corporate technology and intellectual property law firm that also passionately litigates in these areas of practice. Shareholder oppression can usually occur, but not always, when majority shareholders misuse their power to oppress minority shareholders. There are numerous activities where the majority may engage in such activities, and these are referred to as sharp practice or boardroom tactics. Pardon me. At its core, in this video, we discuss the potential relief available under the Corporations Act, what actions of the majority can constitute actual oppressive conduct, and some actual examples from the case law which involve shareholder oppression. Part 2F1 of the Corporations Act contains the law on oppressive conduct in relation to shareholders. Section 233 of the Corporations Act 2001 grants broad powers to the court to make orders for relief for oppressed shareholders, including the winding up of the company, the modification of the constitution, and the transfer of shares, amongst other options for relief. However, in order for the court to make these orders, a person with standing must make an application to the court. So that begs the question, who has standing to make an application? Section 234 of the Corporations Act generally limits the person who has standing to make an application to the following: an existing or past member / shareholder of the company, the recipient of shares in the company, or a person who ASIC considers appropriate having regards to ASIC's investigations into the conduct of the company. Section 232 of the Corporations Act sets out the grounds on which a court may make an order under Section 233 if the conduct of the affairs of the company is unsatisfactory. These grounds include circumstances where the conduct of the company's affairs, or an actual or proposed act or omission on behalf of the company, or a resolution or a proposed resolution is either contrary to the interests of the members as a whole, or oppressive or unfairly prejudicial, or unfairly discriminatory against a member or members. Whilst each case will depend on its own circumstances and facts, the underlying tests of fairness, there are certain current recurrent themes in these cases. Some examples where a court has made a finding of oppression include situations where there is an improper diversion of business to another entity related to the controller, where there is a payment of excessive remuneration to a controller or associate of the controller, or other misuse of company funds, where there's a failure to prosecute a legal action, or where there's an improper issue of shares, or one of my favourites is an improper exclusion from participation in management of the company. These examples are by no means limited, of course. So if you're a shareholder in a company and have a genuine concern about the actions of those with a controlling stake and looking for a commercially savvy law firm to advise you on shareholder oppression, please don't hesitate to call me on 3221 0013 for a confidential and obligation-free discussion. Thanks for watching.